I want to start this video out by saying all constitutional rights invoked, none waived. I want to start this video out by saying all constitutional rights invoked, none waived to my beautiful and brave. All right, we gonna get into this. Class is in session. We about to talk. This now. I'm warning y'all right now that you might want to grab, a snack or something and get comfortable, because we gonna be a minute, because I'm about to get it all into this. And this is important for any and everybody that live in the United States. If you live in the United States, this is going to be important to you, and it's going to be applicable to you. Okay, so we gonna get right into it. All right, now, as you guys know, before I get into this document, this document is about the lawsuit concerning justice for Moses, my brother Moses Monwell McCormick, aka Laoshu505000, who was murdered due to the negligence of the Department of Justice and the American federal government, okay? Because they stood back and they allowed us to be in the courts and get abused while we begged for redress. And the courts were abused, the district courts were abused in violation of the Fifth Amendment's due process provisional clause. And the state courts was violated under the 14th Amendment's due process and equal protection clause. Okay? All in violation of the good faith covenant, okay? In violation of their oath of office, and in violation of 18 U.S.C. 241 and 18 U.S.C. 242 due to it being a violation of the United States Constitution. Okay? Now we gonna get right into it, okay? Now what you looking at here is you looking at something called my appellate reply brief. Now this is a reply brief that I had to file simply because I filed a appellate brief with the Federal Circuit Court because the Federal Court of Claims threw out my lawsuit because they alleged that they did not have subject matter jurisdiction over the United States Constitution, okay? And primarily under Marbury versus Madison's holding, they do. And under the Tucker Act, they do. And under the naked Constitution itself, with just the constitutional provisions under Article 3, subsections 2, they also have jurisdiction. Okay? Now, what we're going to do is we're going to supply the case law citations and the necessary case law citations to exemplify that they are liable for breaking the good faith covenant, they are liable for breaking their oath of office, and they are liable for their negligence, and it's ultimately because they breached the express implied contract, both dealing with the oath of office and dealing with the covenant of good faith. Now let's get right into it, okay? Starting off at number 2, okay? It says, what are your arguments in response to the respondent appellee? I said the appellee's arguments are presented erroneously and they fail to understand that the government breached their contract with the people, okay? And I, Mark McCormick, and Moses Monwell McCormick are two individuals who haven't had inalienable rights protected by the United States Constitution. When the government breached their express and or implied contract, which is their oath to the United States Constitution, it resulted in the death of Moses Monwell McCormick and the attempted murder of me, Mark Anthony McCormick. The totality of all acts were permitted by the United States government. The United States government and its agencies have an obligation to bring any public official with the oath of office to justice for breach of their oath of office, but they did not. They helped to kill Moses Monwell McCormick, and they helped to attempt murder on me by standing by idle as if they were watching a battle like Priscus and Verus. Okay. Number 3, are there other arguments you wish to make? Yes. If yes, please state them. On page 4 of the appellee's responding brief, which is the United States is the appellee in this matter, they misrepresented the fact that the United States is liable for the acts committed by its agencies, okay? And we have the case law to support that. The appellee also erroneously determined that I failed to allege any basis for the court's jurisdiction. The United States Constitution's jurisdiction is broader than the jurisdiction of its congressional counterpart. The United States Constitution's jurisdiction is governed by the U.S. Constitution's U.S. Constitution Article 3, subsection 2, whereas federal question jurisdiction, which is its counterpart, is narrowly interpreted under 28 U.S.C. SS 1331. See the attachment for further clarification and why this is relevant. Also see additional information in the attachment to understand that the United States breached the implied covenant of good faith. Okay, getting right into it. Okay, now this page right here is going to tell what the attachment is all about, okay? So right here in this page, this is telling you, what the attachment is going to set forth. And the attachment is going to set forth these things, these key things here. And it's also going to set forth a little bit more in depth, okay? And we're going to get right into it. So let's get into this very slowly. Okay, the following attachment and citations explain and support why the Court of Federal Claims does have subject matter jurisdiction under the Constitution of the United States and the Tucker Act as well. It also explains and clarifies that the United States and its agencies is responsible for the acts and breach of oath of office which binds them contractually to uphold the United States Constitution primarily over an act of Congress, okay? It also supports that redress under the First Amendment of the United States Constitution allow redress in the form of monetary relief. So the government has not shown or exemplified any proof that redress under the First Amendment is non-money mandating. It can be more broadly interpreted than a congressional statutory provision. For example, okay, for purposes of example, cases arising under the Constitution is governed by U.S. Constitutional Article 3, SS2, and it's broadly interpreted, okay? It's broadly interpreted to allow the flexibility in that, okay? For all unique situations, all right? Now, that's versus the cases arising under federal question jurisdiction is governed by 28 U.S.C. SS 1331. It's narrowly interpreted, okay? Now, the district courts, which are the federal courts, are predominantly governed by 28 U.S.C. SS 1331. But we're just using this for an example to show that the United States Constitution's, the naked Constitution without the statutory congressional version counterpart just on itself is governed by U.S. Constitutional Article 3 SS2, which is broadly interpreted, and we're gonna show that in here. The point is the constitutional provisions are more broad than their congressional statutory counterparts, okay, in all situations. The First Amendment is money mandating, okay? It is, and it can be broadly construed to be money mandating because where there's a right, there's always a remedy, as set forth in Marbury versus Madison in our opening brief, okay? Let's get right into this shit. Constitutional provisions and federal laws that support that the United States is liable and the Court of Federal Claims is the proper venue, okay? Roman numeral 1. My reply to appellee's responses to informal brief questions. Number 1. Has the appellant ever had another case in this court? If so, state the name and number of each case. And so this is me. I said I agree with the appellee, which is the United States, and I have had no previous cases in this court. Okay? Second question. Did the trial court incorrectly decide or fail to take into account any facts? If so, what facts? Okay, now this is me saying I disagree with the appellee, which is the United States again. Her response is problematic because she recognized that I advise the Court of Claims that its agencies breached their oath of office to the United States Constitution. The oath is the express/implied contract that was intentionally disregarded when the United States and their agencies ignored I, Mark McCormick, and my now deceased brother, Moses Monwell McCormick's invocations to the United States Constitution in their courts and law enforcement agencies. Okay? So they was rebellious. Okay? They was very rebellious. All right? This is ipso facto why the Federal Court of Claims have subject matter jurisdiction, because the United States are liable for the acts of its agencies and they breach the implied covenant of good faith. Laws that set forth liability on the United States for the acts of its agencies. The United States are liable for allegations that directly involve federal entities or the United States agents. See Pilkin versus United States, 97 FED 71, 75, 2011. This law rebuts the Federal Court of Claims allegations in their order that they cannot hear cases involving federal judges and other federal personnel. A violation and refusal to offer redress under the First Amendment is an irreparable injury and is recognized as such under federal law. See L. Rob versus Burns, 427 U.S.347, semicolon 6S. CT 2673 semicolon 49 L.ED.2D 1976, which held loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Also see Elmore versus McCammon 640 F.SUPP.905 1986, which held the right to file a lawsuit pro se is one of the most important rights under the Constitution and laws. The United States agencies stood back and allowed the Constitution, which my brother and I invoked on all pleadings and all requests for help from the United States, to be ignored, and they sat back and made us beg for redress while allowing the federal court proceedings in all of our cases to be thwarted in violation of the Fifth Amendment, and all our state court proceedings to be thwarted in violation of the 14th Amendment's Due Process and Equal Protection Clause. We had no real and proper and fair proceedings because the people that are employees, which consists of judges, law enforcement personnel, and clerks, were all being controlled by the commands of the cabal instead of them following the commands of their oaths of office, which is an express and implied contract to the United States Constitution. Cooper versus Aaron, 358 U.S.1, 78S.CT.1401 1958 holds no state legislator or executive or judicial officer can war against the Constitution without violating his solemn oath to support it. Okay? So you breach a contract automatically when you violate the invocations. Okay, class is in full session. Let's get into this shit. The aforementioned law cited supports that the allegations and evidence to support it that was filed in the lawsuit in the United States Federal Court of Claims is adequate to prosecute the United States for breach of contract and violation of the United States Constitution, specifically for the covenant of good faith and fair dealings, which imposes obligations on the contracting parties, including the duty not to interfere with the other party's performance and not to act so as to destroy the reasonable expectation of the other party regarding the fruits of the contract. Syntax Corp, Syntax Corp. V. United States, 395 F. 3D1283, 1304 Federal Circuit, 2005. Further, government employees. Okay, let me read that. Let me read that again for Judge Solomson. Okay. Further, government employees are presumed to perform their duties in good faith. Okay. Hence, the good faith covenant. Okay. See, Torncello versus United States, 681F.2D 756,771 CT.CL.1982 semicolon A at ASCO versus Falcon the Second Shipping Company versus United States, 32 Fed.CL.595,604 1994. Thus, in order to state a claim premised on a violation of the implied covenant of good faith and fair dealings, it holds plaintiff must allege and prove by clear and strong evidence specific acts of bad faith on the part of the government. ASCO Falcon, the Second Shipping Company, 32 Fed.CL.AT 604, quoting Conto collection and disposal, INC versus United States, 29 Fed CL.644, 652 1993. A plaintiff must allege and prove facts constituting a specific intent to injure the plaintiff on part of a government official. Douglas Leroy Reyes and John Tucci, Algernon Marbley, and Diane J. Humatewa. Okay? Rodriguez versus United States, 69 Fed.CL.487, 499 2006. Facts that, if proved, would constitute malice or an intent to injure. Okay? That's Southern Cal Edison versus United States, 58 Fed.CL.313, 325 2003. Okay? The Court of Federal Claims possesses jurisdiction to entertain claims of breach of contract, including claims that the United States violated the implied covenant of good faith and fair dealing, which violates their oath of office to support, protect, and defend the United States Constitution against enemies, foreign and domestic. The appellate, I, Mark McCormick, and my brother, Moses Monwell McCormick, are third-party beneficiaries of the oath of office to the United States Constitution of all federal agents that we petition to act on our behalf consistently with the obligations contained in their oath of office and the provisions set forth in the United States Constitution that guarantee our inalienable rights. The aforementioned laws and explanations are very clear why the Federal Court of Claims erred in dismissing the action against the United States. The Appellee's Counsel's contentions are inept and are not properly aligned with the idea of substantial justice guaranteed under the United States Constitution. Number 3, did the trial court apply the wrong law? If so, what law should be applied? This is me saying I disagree with the appellee. The appellee provided the following response. No, the Court of Federal Claims did not apply the wrong law and properly dismissed Mr. McCormick's complaint. The court correctly determined that it lacked jurisdiction over Mr. McCormick's claims against individual federal judges, officials from the Federal Bureau of Investigation, and officials from the Department of Homeland Security because if the relief sought is against others than the United States, the suit as to them must be ignored as beyond the jurisdiction of the court. United States versus Sherwood 3112 U.S. 584-588-1941. Now let's pause for a minute. Let's address this, okay? Now y'all just heard me read the case law that was put in place by this federal circuit court that says that the United States and its agencies and federal actors are liable, okay? So what is this here? What is this trash? Okay, so what is that? What does that mean? If you are a federal person that has a contract with the United States Constitution, okay, a oath, all right? Then when you breach that oath, then you representing the United States. You was contracted through oath. You don't get your paycheck until you sign that fucking oath. Okay? So if you don't have no oath, you get no pay. So no oath, no pay. Okay? No oath, no job. All right? Okay? So in other words, she was trying to put this argument up. Matney Elizabeth Roth, the government's attorney, was trying to put this case law up saying, oh, well, we can't hear the case because, you know, it involved the misconduct of the judges. They don't get to just get a free pass for the misconduct. So then if you try to take them to court, you're going to give them judicial immunity. Like, y'all can't play that game with me. You can't play that game with me. And the judicial immunity do not trump constitutional invocations anyway. Y'all were improperly trained and improperly applying those when people invoke constitutional rights. That's the highest law of the land. You don't get to use a congressional statute, okay, to say, oh, well, this is that, because then that means Congress get to determine what inalienable rights is and not the Constitution, which is erroneous. Y'all been scamming people. You've been a very rebellious government, and it's time for y'all to get it together. This is going to be the precedent where y'all clean up y'all act and stop disregarding people's constitutional rights, and where y'all need to let people recognize Constitution Day is September 17th, and it need to be recognized more, okay? This Constitution is so important and so powerful, it has its own day, okay? But people outside of Congress and outside of law enforcement don't know that. But they gonna know it now, okay? Because that's what my brother died for. So I'm going to make sure these motherfuckers know it. Moving right along. The appellee's response is inconsistent with the law provided herein and in contravention with the United States Constitution. The appellee's response and the Federal Court of Claims finding in their order is clearly erroneous. We have provided the laws herein that support the United States are liable both under the United States Constitution primarily and its inferior congressional statutory counterpart, which is the Tucker Act. This case primarily arises under the United States Constitution. Okay, now let's get into the language of arising under. We're going to break that down because, see, I'm breaking down everything. I'm chewing it up like a mother bird, like a mother eagle would chew up the food and feed it to their young. Okay, so that's what I'm doing for these little eagles, because they don't understand these babies who think they just so professional and so educated and so, oh, well, we know this, you've been doing it wrong, you've been improperly trained. Now let's go under the arising under language. The Constitution vests federal courts with the authority to hear cases arising under the Constitution or the laws of the United States, which is the U.S. Constitution's Article 3 SS2, okay, which gives a broad interpretation, okay? A constitutional provision is always going to give a more broad interpretation than a congressional statutory counterpart, because the congressional statutory counterpart is always limited to specific actions that need to be taken under the instructions of what Congress put them together to do, okay? And Congress put those together to do that in support of the original constitutional provision that it has to be consistent with. But the congressional statutory version is always a little bit more limited. Okay, so the Constitution is created. It's a system, and it's a little bit more powerful than the congressional statutory counterparts. Okay, getting right into it. All right. So Congress vests the federal district courts with subject matter jurisdiction over cases involving questions of federal law. The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. See 28 USC SS 1331, which governs the civil actions in the district courts, okay? And as we stated in here, okay, I'm going to pause for a minute. As we stated in here, the district court was not an adequate venue for us, okay? It was not an adequate venue for us because we have been consistently abused there and foreclosed, okay? And the latest action happened this year with John Tucci and Douglas Leroy Reyes because he wanted to preclude me from utilizing the national personal jurisdiction against these crooks in Florida. Okay, so we got the whole jig. The whole jig is up. So the United States Federal Court of Claims is the adequate and most proper and the best venue for us because it can address all issues in its totality directly against the United States government without having to name individual actors and all this and all that, because we don't need to get into no more time wasting. There needs to be no more time wasting on this, okay? Somebody already lost their life, which it could have been prevented, but these people wanted to sit back like they was watching The Matrix and eating popcorn. So now it's time for them to pick up the pace and put some pep in their step with this. Okay, so this is how we doing it. We gonna do this in the federal court of claims. Okay, they gonna accept responsibility for this bullshit. All right. The United States Supreme Court has interpreted the statutory arising under language in 28 USC SS 1331 more narrowly than the constitutional arising under language in the U.S. Constitution's Article 3 SS 2. Both the Constitution and 28 USC SS 1331 use the same arising under language. The United States Supreme Court has interpreted the constitutional use of arising under differently than the congressional use of arising under. Article 3 arising under jurisdiction is broader than the federal questions jurisdiction under 28 USC SS 1331, citing Verlinden BV versus Central Bank of Nigeria 461 US .480, 495 1983, holding that the Foreign Sovereign Immunity Act of 1976 does not violate Article 3 of the Constitution. This supports that the Federal Court of Claims must understand that because we are bringing our action under the United States Constitution primarily, the jurisdiction is broader than the congressional counterpart, which would be the Tucker Act in this case, okay? The Tucker Act, the principal statute governing the jurisdiction of the Federal Court of Claims, waived sovereign immunity for claims against the United States not sounding in tort that are founded upon the Constitution, a federal statute or regulation, or an express or implied contract with the United States, 28 USC SS 1491, 2012. And I'd like to highlight, however, the Tucker Act is merely a jurisdictional statute and does not create any substantive right enforceable against the United States for money damages. United States versus Testing 424 U.S. 392 398 1976. Instead, the substantive right must appear in another source of law, such as money mandating constitutional provisions, which is the First Amendment's redress clause, okay? Statute or regulation that has been violated, or an express or implied contract with the United States. Okay, citing Loveladies Harbor Incorporated versus United States, 27 F.3D 1545, 1554 Federal Circuit, 1994. The United States government can adopt a right to a remedy under the Constitution itself. In the context of constitutional rights, the court in 1971 recognized, in the absence of any federal statute, an implied damages remedy to compensate persons injured by federal officers who violated the Fourth Amendment's prohibition against unreasonable searches and seizures. See Bivens versus 6 unknown named agents, 403U.S.388, 397, 1971. Since Bivens, the court has recognized a similar for violation of the equal protection component of the Fifth Amendment's due process clause. See Davis versus Passman, 422U.S.228, 248-49, 1979. And an Eighth Amendment cruel and unusual punishment clause violation. See Carlson versus Green, 446 U.S. 14, 19, 1980. In all those cases, in all those cases, the court has approved of an implied damages remedy under the Constitution itself to satisfy the First Amendment redress of grievances clause. See Ziegler versus Abbasi, 582 U.S. at 2017. The court's acts in the aforementioned cases were consistent with the First Amendment redress guaranteed to the plaintiff therein. Did the trial court fail to consider important grounds for relief? If so, what? Okay, what grounds? And I said this, I disagree with the appellee. She provided the following response. No, the Court of Federal Claims consider all allegations made in the complaint. In response to question 4 of Mr. McCormick's alleged in response to question 4, Mr. McCormick alleges that the appellate invoked all constitutional rights, waiving none, and that the lower court failed to heed those invocations. ECF number 7, INF BR item 4. This argument restates Mr. McCormick's allegations in response to question 2 and 3. Thus, as explained above, in response to questions 2 and 3, the trial court properly held that Mr. McCormick failed to allege any basis for the court's jurisdiction. Now, let me stop there. She was very, very, very deceptive in that, the United States attorney was, because she tried to make it seem like I was just repeating myself, and she was disregarding the clarification that I was providing in those answers that I responded. You know, I was providing clarification in those answers to support why this court was the best venue and the adequate venue due to foreclosure of constitutional rights. And because we invoke the constitutional rights, the First Amendment allow us to get redress in this court, because it is and can be construed as money mandate and consistent with violation of the implied good faith covenant and its implied contracts and express contract. The response provided by the United States counsel Matney Elizabeth Rofe is problematic for the following reasons. First of all, the response provided by me in question number 2 outlines that the oath of office by the United States employees is a contract. Second of all, it promises to accept the Constitution as the supreme law of the land and uphold all of its constitutional provisions over any and all laws in contravention of its guarantees, which are guaranteed to the third party beneficiaries, which are we the people, all of us, even y'all watching this video. The appellee attempted to curtail what my response outlined in question number 2 in my informal brief. The appellee did not want to exemplify to the court that she understood the answer provided by me to question number 2 outlines that the United States failed to uphold its contractual obligations when my brother and I summoned them to do so via invocations of the United States Constitution, which placed them on fair and proper notice. And that was done in their courts and in their law enforcement offices at the FBI when we met with the FBI and when we contacted Jessica Knight, from the Department of Justice in Ohio, and we attached all that evidence to the original complaint filed in the Federal Court of Claims. Ain't no wiggling out of this. The response provided by me to question number 4 in my informal opening appellate brief outlines that the court failed to interpret the fact that invocations of the United States Constitution takes authority over inferior congressional statutory laws. Okay, you need to get that in your head. This is primarily why the rights governed by the United States Constitution are unalienable, inalienable, and cannot be relinquished unless through express or implied waivers. Invocation of the rights rebuts any presumption of an express or implied waiver of the right. Okay? Number 5. Are there any other reasons why the trial court's decision was wrong? If so, what's the reasons? And this is my response. I disagree with the appellee. Her response is as follows. No. In response to question 5, appellants allege that the trial court failed to consider the totality of facts presented. Okay. However, as discussed above, the Court of Federal Claims correctly considered all relevant facts and applied the correct law in properly dismissing Mr. McCormick's complaint. The appellee's response is problematic on so many levels fathomable. I responded and advised that the Federal Court of Claims failed to consider the totality of facts averred in the complaint and the evidence that was presented with it. In our complaint, we let the court know that the state officials and the federal officials were operating in concert to foreclose invoked constitutional rights on the record of their courts and ignored the Constitution altogether, thus violating their oath of office. Now, let me stop right there for just a second. That statement can be supported by the fact that Allison Backus, that got taken off the bench for messing around in my lottery case, okay, they turned around, the United States turned around and gave her a job as a magistrate at the Arizona District Court. So that supports the fact that they have been operating in concert, and they still operating in concert, and instead of reprimanding her, they gave her a position in the federal courts when she got removed from the state courts, okay? So that supports that. Moving right along. Every state official that works in a public arena and every federal employee must take an oath to the United States Constitution. When a state official breaches that oath, it is the Department of Justice and the FBI's obligation to enforce the criminal provisions of 18 U.S.C. 241 and 18 U.S.C. 242 to protect the invoked rights of the people. Okay? All of us. Okay? All of our rights got to be protected. Okay, even their children, okay? They have not been doing that. Instead, they have adopted customs to render 18 U.S.C. 241 and 18 U.S.C. 242 dead. The court can sua sponte take a review to see when the last time any prosecutions under the said statutes have taken place against state or federal officials violating the Constitution. The lack of prosecuted cases is ipso facto why the federal government has become lackadaisical with respect to people's constitutional rights due to congressional laws like judicial immunity and sovereign immunity, which have been established to render superior constitutional amendments guaranteed to protect and uphold inalienable rights moot. Additionally, the founders of the United States Constitution set September 17th as the designated Constitution Day and Citizenship Day to commemorate the signing of the U.S. Constitution in Philadelphia on September 17, 1787. This was created to constantly remind the people of its existence and its importance. Okay? However, since the United States and its agencies adopted so many customs to curtail the superiority of the Constitution, hardly anyone outside of Congress and politics are aware of this day, which should be outlined and observed on the U.S. calendar as a holiday, but it's not. Article 6, Clause 3 of the United States Constitution, okay? This Article 6, Clause 3 of the United States Constitution is a constitutional provision that requires all public officials to take office with this oath. And then you have the Congressional Statutory version of this, okay, which we're going to talk about that. And you have State laws require this. You're not going to get paid for your public job until you have this on file. Okay? And that's to ensure that everybody that's operating for the public give the power back to the people. And that's why the people got the power. That's why it's we the people with the power. Because guess what? We the people can make the invocations that can hold you to your oath of office. And when you violate it, guess what? You get removed. You get removed. And if you don't get removed, that means somebody is not doing their job, and that body of government need to be sued for the breach of contract and a breach of the good faith covenant. Okay. All right. Okay, the Article 6, Clause 3 reads as follows. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Okay, let's pause there. This will exemplify the fact that you're not even getting paid but until you do this. Okay, so that is a contract that is expressed and a good faith covenant is implied. This is very important because no public official or state official can receive compensation for their duty without first taking an oath of office in support of the United States Constitution as the supreme law of the land and of the several states. This is a constitutional provision which is superior to its congressional counterpart. Its congressional statutory counterpart for judges is 28 U.S.C. SS 453, Oaths of Justice and Judges. Each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, whoever the official is, do solemnly swear or affirm that I will administer justice without respect of persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as blank under the Constitution and laws of the United States, so help me God. This is an express/implied contract, and I am a third party beneficiary of this contract, and the person who signed the contract is contracted with the United States government to uphold the promise. All states have laws that require this oath before a person takes public duty and receive compensation. Now let me pause right there. Okay, the good faith covenant is very important when it comes to this oath of office because all government employees are expected to operate in good faith. Okay, so that's why this is very, very important and applicable to the jurisdiction. Okay, all individuals who are elected or appointed to a public office are required to take an oath of office. For the President of the United States, this is governed specifically by constitutional provision, Article 2, Section 1, Clause 8 of the United States Constitution. For other offices, especially the U.S. House of Representatives, the Senate, and the Supreme Court, this is governed by 5 U.S.C. SS 3331. This is important because to state a claim for a government breach of contract, a plaintiff must plausibly allege the existence of a contract with the United States which requires A, mutuality of intent to contract, which is satisfied, B, consideration, which is satisfied, C, an ambiguous offer and acceptance of the offer, satisfied via acceptance of their salary, D, actual authority on the part of the government's representative to bind the government. This is satisfied by constitutional provision and congressional statutes. Okay. See Biltmore Forest Broad .fm, inc. versus United States 55F.3D 1375, 1380 Federal Circuit 2009. These requirements are identical for both express and implied contracts. Matney. Okay. See traumaserve.grp. V. United States 104 F.3D 1321, 1325 Federal Circuit 1997. A contract implied in fact is one inferred from circumstances or acts the parties An express contract speaks for itself and exclude implications. See Clapp versus United States 263 U.S. 191, 1923. The laws of this court and previous decisions cited herein support that I, Mark McCormick, that I, Mark Anthony McCormick, as the appellant, and my deceased brother is entitled to hold the United States liable for his death and for my attempted murder due to their intentional foreclosure of justice in the courts, in the Department of Justice, and intentional acts committed by the Department of Homeland Security's employee Renee Botama Asamoah, which was all in violation of the covenant of good faith and fair dealings and the United States Constitution itself, thus simultaneously violating their oath to it as stated in Cooper versus Aaron, 358 U.S. 78 S.CT.1401 1958, holding no state legislator or executive or judicial officer can war against the Constitution without violating his solemn oath to support it, period. So that's the automatic violation of your contract, okay? 6, what action do you want the court to take? And this is what I said. I disagree with the request of the appellee, and her response is problematic and in violation of her oath to support the United States against enemies for domestic and uphold the United States Constitution as the supreme law of the land. Matney Elizabeth Roth provided the following response on behalf of the United States. We respectfully request that the court affirm the judgment of the Court of Federal Claims. The response of the United States is problematic and ipso facto exemplary of customs adopted regularly in contravention of the United States Constitution. The appellee represent the government of the United States, and she cannot request this court to ignore the government's contract that it has to support the Constitution while violating her own oath to support the Constitution while doing so. The appellee's response is a euphemism, saying ignore the appellant's constitutional provisions invoked and just throw the case out. Just like they threw away my reply in opposition to her request for a motion for extension and then turned around and issued an order with no explanation provided and with no governing law to support it, this case shall be remanded back to the United States Federal Court of Claims with instructions consistent with the constitutional provisions and federal law cited herein, and shall provide redress under the First Amendment of the United States Constitution to me, Mark Anthony McCormick, who is an indigenous Choctaw American Indian, United States national with no African heritage and no ties to Africa, therefore cannot be classified as an African American. But you know who is an African American? Elon Musk. That's an African American. Moving right along. The United States Federal Court of Claims order rendered. The United States Federal Court of Claims dismissed my case under RCFC 12H3, erroneously citing Foden versus United States, 379 F.3D 1344, 1354 Federal Circuit 2004, which was inconsistent with the decisions of this court and in contravention of the United States Constitution, and all who acquiesced breached their oaths. Okay? All who acquiesced breached their oaths. Okay? On page 2 of the opinion and the order rendered by Judge Solemson in the Federal Court of Claims, he alleges that in this case, plaintiff's complaint alleges a bevy of tort, statutory, and constitutional claims. Solemson identifies that constitutional claims were identified in the complaint filed therein. Paragraph 2, last sentence, page 2 of Solemson's order, he states, the plaintiff must identify a law that can fairly be interpreted as mandating compensation by the federal government for the damage sustained. Citing Eastport SS Corp. Versus United States. Okay, this is ipso facto why the court's decision is clearly erroneous, because the United States breached the implied covenant of good faith, and when they breached their oath of office, they breached the implied covenant of good faith when they breached their oath of office, The court properly recognized that injuries were sustained, and the First Amendment's redress of grievances clause is broadly interpreted and money mandating, and it's the government's burden to prove that the First Amendment of the United States Constitution is not money mandating and can't mandate payment compensation as a form of redress for injuries sustained. The standard shall be under the preponderance of the evidence. See Lujan versus Defenders of Wildlife, 504 U.S.555, 561 1992, semicolon Brandt versus United States, 710 F.3D 1369, 1373 Federal Circuit Rule of 2000. Federal Circuit, not rule, Federal Circuit 2013. Under the preponderance of the evidence standard, the appellate satisfied the case must be remanded back to the United States Federal Court of Claims with instructions consistent with the cases and their holdings cited herein, and a constitutional ruling of this court consistent with them. Transfer of this case to the federal court where the appellate is domiciled with instructions consistent with this court's decision can also be applicable, but it is not necessary due to the fact that the district court have proven not to be a trustworthy venue for the appellant due to their repeated intentional violations of the covenant of good faith and fair dealings in the United States Constitution. Douglas Leroy Reyes and John Tucci and Algernon Marbley and Diane J. Humatewa. But we ain't really on Miss Diane. We giving her a little bit of a pass because she ain't really do much. But them other three, they did way too much. Okay, especially Algernon Marbley, he did too much too. How you gonna give somebody judicial immunity for ex parte versus Young? The ex parte versus Young doctrine do not allow judicial immunity. Y'all met y'all match. Finally, the United States Federal Court of Claims could have transferred the case in the interest of justice at the bare minimum instead of throwing it out because the injury sustained cannot be denied and was properly recognized by the court. The claims which are supported by evidence are considered non-frivolous. See Gackaway Farms Incorporated versus United States, 834 F.2D 998, 1000 Federal Circuit, 1987. In the interest of justice and in good faith, the United States Federal Court of Claims could have transferred the case to a court that does have jurisdiction for want of jurisdiction if they were operating in good faith and in the best interest of justice. C 28 U.S.C. 1631. The court shall transfer an action to a court appropriate jurisdiction if it finds that there is a want of jurisdiction for a plaintiff's civil action under Section 1631. Okay? 3 conditions must be met. Number 1, the court must lack jurisdiction. Number 2, the case could have been brought in the transferee court. And number 3, transfer is in the best interest of justice. C. Gravy versus United States, 69 Federal CL 95, 98, 2005. I, Mark Anthony McCormick, is fully knowledgeable on the United States Constitution and its provisions and congressional statutory laws that affect jurisdiction. I, Mark Anthony McCormick, as living man and a witness to all the acts committed in their totality, swear and affirm that the United States District Court in Arizona has committed intentional acts to foreclose the exercise of their court's federal personal jurisdiction power that should have been available to me due to the invocations on their record. Federal judges Douglas Leroy Reyes and John J. Tucci closed the door on my attempts to exercise my constitutional rights in the Arizona District Court located in Phoenix, Arizona earlier this year. With the facts stated herein and the evidence, the United States Federal Court of Claims is the adequate and proper venue to provide relief to I, Mark Anthony McCormick, and my brother Moses Monwell McCormick, who is now deceased as a result of the breach of the United States Constitution and the good faith covenant by its agencies and employees such as FBI agents, Department of Homeland Security employees, NSA, CIA, federal prosecutors, federal judges, and more. Conclusion: with respect to the totality of facts, transfer of this case is not necessary because the United States Court of Claims is the best and proper venue. The United States Federal Claims Court decision shall be reversed. The fuck? All right. Okay, and that's it. That's it. We're going to move right along. And I'm going to share a little clip with you. I'm going to show something from the British Museum, and it shows a picture of the indigenous people of America. Okay? Because a lot of you probably was thrown off when I said that I'm an American Choctaw Indian. I'm American Indian Choctaw. Okay? So that's what I am, and so we're going to show something from the British Museum, okay? Thank you guys for listening. All right, class is adjourned.
Your angels want you to know that there's something that happened to you that you are not fucking imagining, okay? Let's find out. Oh, crap, my phone already fell. There's literally something that is about to fucking fall apart. Something that happened to you that you're not imagining, okay? And whatever this is going to be working in your freaking favor. Okay, dude, there could have been some sort of cover-up. Something that happened to you. Whatever happened to you, you're really being protected right now, regardless if you feel it or not, okay? And this is the last motherfucking call that your angels are giving out. I just heard before, they're not going to give any mercy to these people who were working undercover, okay? Yeah, there's people who could have secret accounts of you, but the AirTag and GPS tracking came out, so that means that there's literally people that are either physically keeping track of you, okay? Or these people are really keeping a close eye on your socials, and what they're really seeing is that you're in this state of like self-love, okay? And dude, private property and firestorm, okay? Somebody could have something that belongs to you, or there could be something in your name, I just heard. If this is resonating with identity theft or something along those lines, but the firestorm card, okay, dude, there's going to be a lot of karma that's about to be delivered. 144 on my timestamp. A lot of drama happened in your life, a lot of endings and a lot of fucking loss, okay? Could have caused you to have a mental breakdown, but now whoever took whatever they took from you, there's a firestorm, literally, dude, that's about to rain down on these people and put them in their own spiritual debt or physical debt, I just heard. Yeah, Archangel Michael is protecting you right now from literally evil. I have serious chills, okay? It's like you have so many countless stalkers that is like you don't know. Yeah, it's like everybody is a little sus to you, like a little suspect. It's like there's so many freaking stalkers. I just heard the amount of stalkers that you have should literally be studied. And it's like caused you to go through like spiritual warfare, hardcore, okay? A lot of people could be astral projecting into your dreams. Either that or you are really going out into the astral and exploring different parts of yourself, I just heard. You could have came from a crooked family and you're really trying to give yourself a motherfucking fresh start. And it's like, when you cut these people off, they had massive regrets for you leaving, but it's like the red flag was up, so you cut it off, okay? You are the black sheep. You literally defy all the odds. And I just heard like, you would be the cause of like a rebellion. Like you are a serious rebel. And these people were karmic ties anyways. But it's like, you've been using your intuition, dude, and really standing in your power here, because the mind control that these people tried to use on you is no longer working, okay? They could have tried to blackmail you, thrown spiritual monkey wrenches towards you, aka like dark magic, speaking bad on your name. This could have been a masculine energy, okay? But you are literally viewed as somebody who is always moving towards their life purpose, okay? You are like the North Star. Your intuition, I just heard, really, it honestly leads the way, not only for you, but for many many people, okay? And whatever the fuck this cover-up is, because it just popped back out, you're being guided to move exactly how you're moving. I just heard if you're being given directions or like things are popping up in your head and you're second guessing if you should be doing this, you should be doing it, okay? Follow the energy, follow your intuition. These people literally, dude, I just heard the behavior is so fucking irrational, okay? 911. There could be some police assistance. You could have made a police report. You could have gone out, done something, and never received help. But now, all these perceptions, everything is being shattered, okay? And you no longer have to sit here and cope with the fucking pain because you healed from it. And that is what all this corruption, dude, all of this, like, dude, yes, round and round, dude, cycles, triggers, just going round and round, okay? You are being guided to literally your north node, okay? You are literally being guided to your life purpose. And it's because you're going through all this shit, okay? There's gonna be physical evidence that comes out. Literally, I just looked at in your favor again. Whatever happened to you, you did not imagine this, okay? It's all fucking working out. I love you so much.
American Indian. Okay. Constitution gotta be supported and enforced and defended. I'm indigenous to this land. Okay.
To have a long-lasting relationship and an honest relationship with your partner. Like that, live like your grandmama and your granddaddy. I can live like you. You see how your grandmama and your granddaddy live? Live like them. You don't get relationships like that no more. Yes, you do. Because it's in your blood. It's in your blood. Your blood comes from them. Them two. and me. See what I'm saying? Now you got that fight spirit for me. If you got it.
I got it.
Well, how about you help me find a husband? Huh? How about you help me find a husband? I need me a good old one. I need him about 60 years old. That's all. It doesn't matter. It ain't the oldest. It ain't the youngest. It's the treatment. Mm-hmm. It's not the oldest, Amber. It's not the good-looking one, Amber. It's not the one got money, Amber. It's the one honest. And not too many of them honest nowadays. Oh, yes, you can. Yes, you can. There's some good men out there. But what it is now, it's the women. It ain't the men no more. The women going bad. The women's going bad. It ain't the men's now. It's the women done gone bad. You gonna flip the script on us? Yeah. It's the women done gone bad. You a woman yourself. I'm a woman myself, but I don't do half the things I see these women do now. They don't care no more. That's the reason the men don't respect them. That's why. Let me tell you something, Amber. You got to give a man respect to get respect. You know what I'm saying? You got to give your husband respect to get respect. Because as long as you respect him, ain't too much he gonna do wrong.
Okay, guys, so here's the thing with these group stalkers, okay? A lot of these people are low-key, totally obsessed with you, or they wouldn't be stalking you the way they're stalking you anyways, right? They gotta keep tabs on you. I want you to think about it like this. They gotta keep tabs on you. They gotta know what you're doing at all times. They gotta know who you're with. This goes just a little bit deeper than wanting to entrap somebody and keep them imprisoned, okay? This goes further than that. These are people that low-key have a sick obsession with you, or else they wouldn't be doing what they're doing. But here's another thing about this, guys. If they were gonna do something to you while they were group stalking you, they would have done it, okay? They're sending people to keep tabs on you for a reason, right? They want to know your schedule. They want to know everything that you're doing. Like I said before in some of my other videos, to plan a future attack. This is why I said in some of my other videos, it's imperative that you know how to protect yourself. It's imperative that you know self-defense. It's imperative that you carry a weapon to be able to protect yourself at all times. And don't ever let it leave your side. Their goal is to set you up, to stalk you, to keep tabs on you, to keep you in prison, where they can sit there and study you and watch your every move. People don't group stalk people for no reason. They have a main objective, and 9 times out of 10 it's because they're using 1099A and 1040V vouchers in their court system to collect money off of targeted victims' deaths. This is how a lot of these corrupt court systems make their money, off of targeted individuals' deaths. I wouldn't call it life insurance, acquisition of abandoned funds forms. This gives these people access to all of your money, right, that's under your name upon death. This is all for money. These people don't just do this shit to try to scare you. Don't let it scare you. Ain't none of them about shit. Okay? Just know that there's a price on your head. And for them to be coming at you as hard as they're coming at you, it's got to be a large price. Like I said before in some of my other videos. Document, post, use TikTok to your advantage. Build your own case. Have important people watching. Send letters. Congressmen, senators, judges, etc. That way, when your name comes through the loop anywhere, they'll catch it. They'll see it for what it is. Governors, attorney generals, keep going and don't stop. When you become a RICO targeted individual, everything that's done to you after that moment will be considered targeting. Period.
Don't know this, and if you know this, this is just your confirmation. Spiritual people hold an ability, and you have an ability to read people. You have an ability to see through the facade, see through the illusion, see through lies, just see through deception. You know how to read people extremely well. In some cases, y'all are highly intuitive. Y'all carry this gift called discernment. You know when something is not right. You know when you've been spoke about. You know when people don't like you. You know when, like, you read energies. You read body language. It's just a natural born gift when you are a spiritual person and you tap into your higher self. See, you not the one people can easily fool and manipulate. In a lot of cases, spiritual people are natural born loners. In a lot of cases, y'all slay demons. Y'all be prophesizing and y'all got this anointing spirit that hovers in you, and you expose people for who they are. You may not even know that you exposing them, but a lot of y'all slay demons. A lot of y'all reveal to people who they actually are, and that's why you got a lot of enemies. In some cases, y'all don't even have friends at all. People don't like being around you. They suddenly change up and switch up on you. They just suddenly become an enemy of yours because they can't take you. They can't take your truth. They can't take your anointing. So when they can't take you, they turn up against you. Spiritual people are very high ranked in the kingdom of heaven. Spiritual people are those people you cannot play with at all. God will speak on their behalf. They are not the ones to come for. In some cases, they are people that have really pure hearts, and they also have a dark side.
We gonna break down they shit.
Any final words for the people?
Au revoir.
See, as you can see, the more you fuck around, the more you're going to find out.